Right now, I want to welcome another Robert to Farmville, Virginia, at least over the telephone. Dr. Robert Young with Doctors for Responsible Gun Ownership is with us on the program. Dr. Young, how are you, sir?
Very well, Cam. Robert is one of the best names in the business. I'm very pleased to join him.
Well, I appreciate you spending some time with us today. We've been talking about this decision out of the 11th Circuit Court of Appeals, and this is the second decision out of the 11th Circuit Court of Appeals on this very case, the Wollschlaeger decision. Originally, a three-judge panel upheld this Florida law that barred doctors from talking about gun ownership with their patients unless it was medically necessary. An en banc review by the 11th Circuit reversed that decision and said, no, you can't tell doctors that they can't discuss gun ownership with their patients unless it's medically necessary. They can bring it up as often and as loudly and as vociferously as they want.
Right. And we at Doctors for Responsible Gun Ownership, as well as I think the entire firearms community, are very disappointed about this decision, of course, particularly because each of the previous well-considered decisions on this case have come out in our favor. So it's very discouraging to see the full panel of the 11th Circuit with all the background that is developed through the repeated cases that have come before other courts and itself, essentially contradicting everything that's come before.
In what way? When you look at these lower court decisions, either at the district level or the original three-judge panel, obviously they were still considering that same argument of, look, this violates the First Amendment rights of these physicians. Why did the court say, no, this law was crafted in such a way that their First Amendment rights are not violated?
Well, first of all, because they weren't. First Amendment rights apply to the right of any individual to speak their mind. That's what you and I are doing right now.
Mm-hmm.
But that doesn't give me the right as a physician to influence patients in the privacy of the exam room when my job is to address their needs, particularly their medical and clinical needs. That's at the heart of the matter that the Florida Firearm Owners Privacy Act, or FOPA, was intended to assure. Now, it appears that one reason for this very different decision on the part of the full panel is explained by Judge Jordan, the beginning of Judge Jordan's majority decision. In it, they say this was decided as a First Amendment issue, not as a Second Amendment issue. So they basically just looked at the, quote, free speech issues and not at the issue of the risk of impeding, infringing, if you will, people's Second Amendment rights through unknowledgeable counseling. Now, that was not the way it was looked at before. We posted an article today on DRGO about this. It goes into great detail, particularly thanks to the help of Joseph Greenlee, who's the attorney we worked with, along with the Second Amendment Foundation and the Citizens Committee for the Right to Keep and Bear Arms, in writing the amicus curiae brief that we submitted, which seemed to be basically ignored. At certain places, the court said there's no claim or evidence or contention about things that we claimed, showed evidence for, and contended in our very, very brief. The balancing issue between two constitutional rights is critical in this kind of case, and it was essentially ignored. The Supreme Court, in a number of cases, up to about 20 years ago, established that there's a test called the Gentile, Gentile, balancing test that's to be used in balancing the trade-offs between one constitutional right and another. Mr. Greenlee made a great point of this in our brief, and it is established law, an established principle to be followed by any inferior court, which includes this one, and it was simply ignored. The whole majority decision was based purely on the impression that doctors' free speech was being infringed.
Talking again with Dr. Robert Young with Doctors for Responsible Gun Ownership. And, doctor, with this decision in place, what is your advice to patients who may run across this when they're, talking with their doctor and all of a sudden they believe the doctor is, venturing into areas where the patient doesn't want to go? Do they have the right to say, I'm not answering these questions?
Absolutely. Patients have always had that right. And there is one point of light in this decision that, in fact, supports that. It does protect the right of patients to be served by physicians, even if physicians disagree with their position on something like gun rights. In the past, at least in Florida, there's been some risk that a physician could rationalize discharging a patient just because he didn't like their attitude about guns. This decision affirms that is a no-go territory for doctors. Now, that doesn't mean your doctor may still not like your position on guns or your refusal to answer a question about them if that's your decision or whatever. But what to do about it is something that we have covered on our website, drgo.us. On the first page there, you'll see a post highlighted that says that is titled "What to Do When Your Doctor Asks About Your Guns," and that's good advice there, we think.
Excellent. Listen, doctor, I really appreciate you coming on the program, sir. It is always good talking with you, and I hope we get a chance to do this again very soon.
Always an enjoyment for me, Cam. Take care.
You too, sir. Dr. Robert Young with the Doctors for Responsible Gun Ownership joining us here on Cam and Company.